Now, it's always a good idea to try to get the trial court to address it if you possibly can, but don't give up if you raised it and the trial court didn't address it. The hard part comes up when you have an issue that you've raised and that requires factual findings and the trial court failed to make them. In that case, it really behooves you to try your best to push the trial court to make the factual findings that you need to come up on appeal, and to make them in what I would call an articulate way, that is either through a written order or through oral findings of fact, so that there's something for us to review. We understand as judges on the Court of Appeals that sending a case back to the trial court for any reason is usually not a happy place for people. It's not something we do abruptly, willingly, happily, without thought. And to send it back on remand for findings of fact just prolongs things. So trying to get those findings made in the trial court before you come to the Court of Appeals is a great idea. Preservation, it helps to remember that the error of law that has to be preserved or brought to our court is one that's made by the trial court and not by any of the lawyers or the parties. We have these preservation rules for a couple reasons, and they are to basically induce litigants to fix errors, to eliminate prejudice, and to create a record that we can review. And as I said, we hope that everybody's goal is to get a fair and accurate trial the first time around. One of the things that we see occasionally is that people try to preserve an issue in a motion for reconsideration. And that, I stress, is not a proper place to raise an issue for the first time. It will be noted by our pre-hearing department or by our law clerks if an issue is raised in a motion for reconsideration for the first time. And as I said, from my own experience, if you want to preserve a sufficiency challenge, it has to be raised either in a motion for directed verdict or in a motion for new trial or in the trial court. Okay, the key to preservation really is to give the trial court an opportunity to fix its mistakes. So how do you best do that? And part of this is tied into how do you create a record that's good for our review or puts you in the best place for our review. So let me talk about evidentiary issues. I mentioned that it's hard to succeed in an appeal if all you have is an evidentiary issue. And that's because our standard of review on evidentiary rulings is for an abuse of discretion, the most deferential standard that we have. So to me, that means that we cut trial judges a lot of slack. They're making these rulings sometimes very quickly. They don't get it right all the time. And if they get it pretty close, we're usually going to uphold the ruling, even if technically it's wrong. And as someone who's been a trial lawyer, who was a trial lawyer for 27 years and tried a fair number of cases, it's really quite remarkable to me how much time I have now as an appellate judge to ponder an evidentiary issue that the trial judges don't have when the trial is really flowing. So I understand much better now the need for and the rationale behind the abuse of discretion standard. Anyway, back to preservation. How do you preserve an evidentiary challenge? Well, the objection has to be on precisely the same ground that you're going to bring to our court. And I don't see this as a problem so much in civil cases as I do in criminal, but just so that you know what happens in the criminal law is there's an objection, say on hearsay grounds, when there's also a potential objection that the lawyer didn't make on Sixth Amendment grounds, constitutional grounds. So that's that issue, the constitutional issue, it can be argued, or it often is argued, has not been preserved. So it's very important that you make the objection on the right ground. And if I were giving advice to trial lawyers, if you as appellate lawyers were to give advice to trial lawyers, I would say, make sure that you object on multiple grounds, even if there's a ground that you're not sure about, but it's a possible ground for objection. I would encourage you to make the objection on that ground. A motion in limine also preserves the issue. So if you've brought a motion in limine and lost, the issue is preserved. Let me strongly encourage that if evidence is excluded that you believe was improperly excluded, it is very helpful and important for you to ask the judge to allow you to make an offer of proof. Having that offer of proof in the record goes a long way towards persuading us that perhaps an evidentiary error is serious enough to make it A, an abuse of discretion, and B, harmful. So of course, those of you who've done appellate work know that the other obstacle in the path of most appellate practitioners is harmless error. So that, in other words, as we all know, judges can make mistakes, but very few of them actually deprive the litigant of a fair trial. And that's pretty much the standard for harmless error, if it makes a difference in the outcome. If you've got an offer of proof in the record, likely it will tell us without too much extra work on our part whether or not the evidence that you sought to include in the record would have made a difference at the time of the trial. Okay, in civil cases, the other area that preservation comes into play a lot with is jury instructions. And what I see a lot of the time is the lawyer saying, after the argument on the jury instruction, something like, "I'm satisfied." That's what the lawyers say. And unfortunately, that gives the other side ammunition to say, you've waived any challenge. You've voluntarily relinquished any challenge to the jury instruction, even if you had at one time objected to that instruction or failed to include that instruction in your proposed instructions filed with the court. So what I strongly urge is that you tell yourself or you tell others that when all the dust settles regarding the jury instructions, your word should be, "I'm satisfied that the court is going to give the instructions that we've gone over. I would reiterate my objection to giving X, Y, or Z, or not giving X, Y, and Z," just so it's clear. I guess the bottom line of my advice is you cannot go overboard with preservation. You can't preserve too much. It's easy to preserve too little. It's hard to go in the other directions. Legal issues are generally very easily preserved. If you participated in an argument regarding a legal issue, there's no question but that it has been preserved. As I said, however, don't think that you can raise it on reconsideration because that won't work. Next, I want to talk about, and this is the part of the talk that's kind of dull, but so also very important for those of you who are doing the nitty-gritty of appellate practice, final orders. Even before preservation, whether or not you've brought your appeal at the right moment is something that's reviewed by our clerk's office. So it's not reviewed by pre-hearing, but it is reviewed by the real specialists in this arena, who are our court clerks, who are the wizards about the court rules governing appeals in our court. If you don't have a final order, if you appeal too soon and you don't have a final order from which you are claiming an appeal as of right, you won't be allowed into our court. You'll be told, come back again later when you have a final order. And that's not so much of a problem. You've spent the money to file your claim of appeal, but at least you're not too late. The problem arises if you file your claim of appeal too late and the order from which you're appealing is not the final order, but an order post final order. If that happens, we lose jurisdiction and there's nothing you can do to revive it. Nothing. The case is gone. There can be, and this is the tricky part of final orders, there can be a number of orders that technically qualify as final under the definition of final order in the court rules. But the rule also says that it is the first final order that controls. So if you haven't appealed from if you wait too long and the order that you're appealing is not the first final order, we have likely lost jurisdiction. So keep in mind that a final order is almost never in civil cases the last order that the trial court enters. It's not necessarily the order terminating your client's participation in the lawsuit. It is most commonly the order that ends the litigation as a whole. And you can find all of this, if you're taking notes, in 7.202 sub 6, which you should have bookmarked in the court rules. It's the first judgment or order that disposes of all the claims and adjudicates the rights and liabilities of all of the parties, including such an order entered after reversal of an earlier final judgment or order. Keep in mind that an appeal as of right cannot be brought from a stipulated order, a consent order, or a consent judgment. Again, I'm not going to spend too much time on final orders unless there are any questions about it. I will say that if you're in practice and you have questions about whether what you've got is a final order, our clerks are pretty amenable to your questions, and you should call and ask and get some advice. They can't give you binding advice, but they might be able to help you a little bit. And again, I would urge you, if there's any doubt in your mind, go ahead and file the claim of appeal and let us reject it as saying it's too early. I asked the guy I referred earlier, the appellate lawyer with whom I live, have there been times when you've filed more than one claim of appeal because our court has rejected it as not the final order? And he said, yes, he thinks his record is 5. So filing 5 different claims of appeal before he got to the order that the court decided was final. Better that way than losing the chance to appeal at all. There are some specialized final orders that are listed in 7.202, and I want to talk about one of them: a post-judgment order awarding or denying attorney fees and costs. Remember this: let's say you have a judgment. Let's say you've lost a case. There's a judgment entered against your client, and you have issues arising out of the trial that you want to bring to our court. You know there's going to be a motion for costs and fees later, sometime later in the future, beyond the time that in which you have to file a claim of appeal. Don't think for a second that you can wait for that order post-judgment order on costs and fees and designate that as your final order. If you have issues that you want to appeal arising from the trial, you must consider the judgment of that issued by the court from that trial as your final order. That's the prime example in which you will have two final orders if you also then wish to appeal the post-judgment order awarding or denying costs or fees. The other big one, since I know I'm speaking to defense lawyers pretty much, is an order denying governmental immunity to a governmental party. Those are final orders, even though the case is moving forward in the trial court, and those can be brought as of right in our court. Okay, let me talk a little bit. I don't see any questions. Boy, please feel free to interrupt. It's hard for me to talk, and I was only going to talk a half hour, and I'm almost there, but I'll keep going. And then I am going to open it up for questions. I want to talk a little bit about the record on appeal. The record on appeal is pretty much frozen as of the time your final order is entered, except for post-judgment events that lead to an appeal of the post-judgment events. And I want to talk about it in the context of summary disposition, since so many of the cases that we see are SD cases. And some of you have heard me say this before. If you are going to attach deposition transcript to your motions for SD, I strongly urge you to attach the entirety of the deposition transcript. Now, do you need it? Is it critical to your record? No, maybe not, but maybe it is. Because what I've seen happen so many times is that lawyers will attach only the 2 or 3 pages of a transcript in their motion for summary disposition. So they'll only attach in the trial court those pages that they think are directly relevant to their motion. And when they get to our court, they realize that there were more pages that should have been attached, or the appellate lawyer realizes, no, you didn't, you should have attached this, you should have attached that, you should have attached this drawing, you should have attached this photo, you should have done that. Too late. We can't look at it. And let me just tell you that that is not a pleasant experience for me as a judge, because 99% of the time, I wish that stuff was there. I wish the whole transcript was there. A case is, for me, much easier to understand and evaluate if I can read more rather than less. If you're asking yourselves, does she really read the depositions? I really read the depositions. I don't know how much of this messy desk you can see here, but I do read depositions. I do read briefs. I do read exhibits. And so do many, if not most of my colleagues. Certainly all their law clerks do. So it's really, really helpful to have materials in the record that will help us to understand your case and to understand the facts of your case. And I urge that in summary disposition, again, you go overboard rather than the other direction to try to provide as many facts as possible. Your trial judge may not want them and may not care about them and may complain. And if that's the case, I would say, just tell the judge, I'm doing this for the Court of Appeals. I'm not doing it for you. I'm doing it for the Court of Appeals because the Court of Appeals may want it and need it. And that's absolutely true. Okay, that's the record. I don't know if there are any questions about that. That ties into our fairly new appendix rule in the Court of Appeals, which has been met with some displeasure, I know, by the bar. And I can talk about it. Let's see. So as many of you know, we require that in your appeals, you include an appendix, which itself includes the judgment or order appealed from, the trial court's docket sheet, the relevant transcript pages, which I've just told you, in my opinion, is all the pages of all the transcripts, a jury instruction. And let me go back on that. Let me go back to why I like appendices that include everything. When I started as an appellate judge in 2007, it was before the era of electronic records. And at that time, all transcripts were in paper. The writing judge on our court, as most of you know, one judge is assigned to write the opinion. And as perhaps you don't know, that assignment comes from the clerk's office. It doesn't come, we don't negotiate it. We don't fight about it. We don't even have any say in it, the panel. The assignment of who's going to write which particular case is decided before the list of cases is even presented to the panel. The writing judge in the old days was the only one who would get the record. So if another judge wanted to read the transcript, we had to wait until the writing judge, the assigned judge, was finished with the transcript. And then it would be placed in inter-court mail. So if I were sitting with somebody in Grand Rapids, it could take 3, 4, 5 days for the transcript to reach my chambers. Now we have the era of electronic records, and we can access the transcripts most of the time through our internal system, assuming that the trial court in which you're working is an electronic filing court. We can access them through a number of what I'll call technological hoops that have to be jumped in order to get into our internal system. It's certainly better because I don't have to wait for the chambers in Grand Rapids to send me the record. But best of all is when I have the transcript attached to the brief, because then I don't have to do any of that additional work, and it's right there at my fingertips. And I really encourage you, if possible, to attach transcript to your not just the pages that are relevant as the rule requires, but the whole thing, especially if you're appealing from a motion for summary disposition and you have transcript of the oral argument that you think would be revealing or helpful to the court. Attach the whole transcript so that we have it. Other relevant, the rule provides jury instructions and corresponding transcript section if challenged. That's pretty self-explanatory. Other relevant exhibits, pleadings, and evidence. And this goes back to, again, talking to your trial lawyers, if you're the appellate team that's listening to this. Often, particularly in civil cases involving property, for example, there will be drawings, maps, photos. And somewhere, those drawings, maps, or photos are in the record, I'm sure, somewhere. But for us, digging through the record to find them is difficult. So if you can attach them to your briefs and include them in your appendix, that's very helpful. So there is a question. So let me see. I'll read the question out loud and I'll do my best to answer it. It's a question about the record. If a document clearly was filed below, for instance, the complaint, but it was not attached to the motion for summary disposition, response, or reply, and is the subject of the appeal, can it be included in the appendix or on appeal as part of the record? Yes. Even though you didn't attach it in the brief on motion for SD, assuming I'm answering the question correctly, it can definitely, it's part of the record because it is part of the record. So the court had access to the complaint or the answer or whatever pleading it was at the time the court ruled on the motion for summary disposition. So we will have access to it as well. What happens, just so that you know, is that when your claim of appeal is filed and accepted by our court, the next thing that happens is our court reaches out to the trial court and says, send us the entirety of your record. So that would include the complaint. It's a good question, but we have it. But, you know, I will say if you have a choice about including it or not including it in your motion for SD, include it. So just so that you know, and I see Mr. Mucha has a question. I'm going to get to it in 1 second, but I just want to tell you how I look at these issues. So if it comes to me, if I'm looking at it, a case, and the issue is summary disposition, and let's say the motion and the answer are not attached to the brief on appeal, I'll go into our system and download or print the motion that was filed in the trial court. So having everything in one place is helpful. I know it sounds like I'm a, you know, as my kids would say, whiny, spoiled, blah, blah. But, you know, just because we do deal with reading thousands of pages of stuff every month, whatever you can do to make our lives easier makes us happier. And that's not a bad thing. Okay, so another question. If opposing counsel simply loads up the record below by attaching all manner of documents as exhibits to a brief file below, without any real discussion of the exhibits, can that successfully preserve an issue for appeal? One of my opponents did that once, and I did not understand what benefit he expected to gain. Yeah, and believe me, we'll notice it. And it's another good question. And no, it does not. Just attaching it doesn't preserve it, because remember, at the heart of preservation is the notion that we give the trial court an opportunity to fix a problem so that we avoid a new trial. So just throwing paper at the trial court without articulating, making, constructing, crafting a legal argument is not going to do it. You have to accompany all that paper with a legal argument. And if you don't have one, and if you haven't made one, I should say, in the trial court, that paper will not save you in our court. You know, as much as I say, I love having a complete record, I do notice when I get, you know, a brief with exhibits that are that big and we've only maybe needed a couple pages. But hey, I'm not complaining. Your job is to give us more information and let us complain about having too much, rather than to give us too little and then be sorry that you didn't give us more. So I want to encourage you that forget that complaint. I just made it, I take it all back, and give us more rather than less. Okay. Any other questions? All right, well, I know I have a few minutes. Nathan, do you want me to keep talking? I can talk for another few minutes, or?
Well, I had a related question actually to kind of those two with respect to how to present the record. I've noticed a lot in summary disposition briefing recently, people love to take a PDF and copy and paste sections of the PDF into their brief. I mean, that's in the trial courts, it's all over the place. It's some briefs that it seems like they're more copy and paste of PDFs than anything else. Do you like seeing inline, you know, citations or to the record in Court of Appeals briefing? Or where is that most effective? I guess
I really do like having the exhibit. I like the PDFs. I like the pictures that are in the record. I like the stuff that I don't have to flip around to find. But remember, it counts towards your 50 pages. So if you're running into problems, that might not be the most effective use of your 50 pages. Just keep that in mind. But you know, like most readers, we don't necessarily like to flip around to find things. So especially, and let me urge that, especially with the facts, it's so helpful. And many of you who've written briefs in our court or in the Supreme Court already know what I'm about to say to be true. And that is, if you can write a persuasive statement of facts, you're halfway to your goal line. Because if you write a statement of facts that's thorough, accurate, and compelling, anybody reading those facts is going to be tilting to your side just after reading the facts. And just so that you know, I mean, I generally look at a brief by whether it's a civil or a criminal case, I generally take a look at the issues presented very, very quickly, just to see, you know, is this a premises case? Is this a case about a sale of something? You know, where am I going here? What's the basic substance? If there's an introduction, that helps me enormously because it really focuses me. And let me just say that I happen to love introductions as long as they're not more than a page and a half, because and then to me, it's not an introduction. It's you know, it's an argument. And then a good statement of facts that really educates me about the facts and includes the things that you mentioned, Nathan, is really, really helpful. So I like that a lot. I think there might be another, is there another question?
Yeah, there's a new question.
Okay. All right, here's the question. A couple new questions. So I'll read the first one. If the clerk's office assigns the writing judge before sending the file to the appellate panel, what happens if the panel splits 2-1 and the assigned judge is the dissenting vote? Do the other two judges flip a coin about who writes the majority? Generally speaking, they work it out. And it's, in my experience, it's the one who feels most strongly about the issue who decides to write it. So yeah, I mean, it happens that the writing judge becomes the dissent, and I've been in that position more times than one. And basically, you know, I say to the other two, you know, just let me know. And when I've been in that position, I always volunteer to be the writing judge if the assigned judge is going to be the dissent. And then we just work it out. It's just a case, you know, who has the most work at the moment and who's the most behind. Generally, that's how we do it, and who feels the most strongly about it. By the way, just so that you know, and I'm going to get to Mr. Bissio's question in a second. The way that our clerk's office does the assigning, just maybe this is too much inside baseball, but if anybody is curious, every case on the case call docket is weighted, WEIGHTED, by research in terms of how difficult the case is, and it gets a score of, I think, 1 to 5, but don't hold me to that. And that score is not given until after the case emerges from the research department. So after the pre-hearing report is complete, the supervisor in research scores it in terms of difficulty. And so every case that's put on the case call list has a difficulty score, and the clerk's office's goal is to make sure every judge every month has an equal number of difficulty points. Does that always work? No, but that's basically part of what goes into who gets responsibility for what judge. It's a numbers game too, and a difficulty game. So there's no, and I'm told, and I have no reason to doubt this to be true, I'm sure it is true, that they make that, when they make the assignments, the names on the case call panel are Judge 1, Judge 2, and Judge 3. So they don't even know who the judges are. So, all right. Getting to Mr. Bissio's question, Ray, final orders, questions. If you're unsure, isn't the better course to file both a claim of appeal and an application at the same time? That is such a good question. And the answer is yes. For the last couple months, and just so that you know, if you have not filed, if you're concerned that your appeal is untimely, if it's too early, you can also file an application for leave and ask us to take it just because it's a good thing for us to do. Applications are heard, for those of you who don't know, by special panels that sit every month by district. So each of the 4 districts has a motion panel assigned for that month. And that motion panel will review, excuse me, all applications for leave to appeal. And in most civil cases, we do get a recommendation on those from our commissioners, our clerk's office commissioners, who dig into the cases before they get to the judges. and advise us as to whether or not a case should be taken out of turn. So Mr. Bisio, you're absolutely right. Filing, if you're worried that you're too early, filing an application can get you started on the appellate road. I hope I've answered the question. Let's see if we have any more.
Looks like there's another new question in the
okay, got it, I think. If a party obtains summary disposition and the case continues against others, what is the best way to address the opponent using materials on appeal that were produced after he left the case? Let me read it again. If a party obtains SD and the case continues, what is the best way to address the opponent using materials on appeal that were produced after he left the case? Does that change when the appeal involved? No, I think you can, I'm not sure I understand the question. You might want to try to refine it a little. If you've been dismissed, so you represent the party that's been dismissed and the party and the case is continuing, you can use materials produced after you left the case. No, if you're appealing your dismissal, if you've actually been dismissed and are appealing your dismissal, the record that is going to come to us will be frozen as of the time that your claim of appeal is filed. So we will not have the anything subsequently filed in the trial court. That will not come to us and that will be considered outside of the record. I hope that answers the question. If it doesn't, please let me know and I'll be happy to try again. Okay, maybe another one. No open questions, okay.
Not seeing any other questions. Any other questions? Last call. Well, Judge Gleicher, thank you so much for your time.
Sure.
It was very helpful and informative, and we really appreciate your insights.
Sure, happy to be here, and I encourage you that if you do have questions while you're working on appeals, our website is a fantastic place to go. Not only are the court rules on our website, but we have our internal operating procedures, our IOPs, which are really helpful, very well indexed, and you should always consult the IOPs that are online to see if those answer your questions. And our clerk's office is fantastic. I have questions fairly often, and I call them and get great answers that they know off the top of their heads. So don't hesitate. So I might have one more question, Nathan. Might have another pop up. I think they're recording this. Is that right? One of the attendees wants to know. So
we are recording this.
Yes, this is recorded.
We have to discuss how we want to release it. Whatever you're comfortable with, Judge Gleicher. We can make this available to attendees if you're comfortable with that.
Yes, I'm comfortable with that. I'm comfortable with that. I don't think I said anything terribly controversial. For once, I think I avoided that. So that's good. Do we have another one there? Oh, no, that's the same question. Okay. All right.
All right. Well, thank you so much.
Sure. Bye, everybody. Great to be here.